Thank you, Mr. Chairman. Mr. Ring, in 2023, the National Labor Relations Board issued the Joint Employer Final Rule, which upends the traditional direct and immediate control standard and creates an expansive, vague, and costly standard. In March 2024, a federal district court struck down the rule because it exceeded the NLRB's authority. Also in 2024, the House and Senate passed a Congressional Review Act resolution to nullify the rule. Despite a federal court striking down the rule and Congress expressing its disapproval, the NLRB decided to appeal the court's decision, striking down the joint employer rule. As former NLRB chairman, would a bipartisan and bicameral rejection of a rule along with a court decision knocking the rule down have been taken into consideration when deciding whether to pursue an appeal?
Of course it would. And I'll just add that there was a very similar joint employer standard that was adopted by the board during the Obama years that was struck down by the D.C. Circuit at least twice. So this standard that they've been pushing is the DOA on a number of courts. Why they continue to push it is puzzling. I always viewed my role at the board as trying to color within the lines. We saw our role as not having a particular agenda, but rather to enforce the statute and interpret the statute the way Congress had written it and as interpreted by the courts. This board does not seem to follow that same approach.
And I'd like to emphasize here that I have a bill, the Employee Rights Act, which clarifies that two or more employers must have actual direct and immediate control over employees to be considered joint employers, and will protect the franchise model by codifying the long-standing definition to prevent franchise owners from becoming corporate middle managers. Mr. Seaton, during Chairman McFerrin's tenure, the board has revised election rules for union representation and decertification elections to diminish employees' rights to refrain from union activity. Can you discuss some of these basic changes made by this board?
Yes, thank you, Representative. Yes, the changes are many throughout the procedural rule, and they, as I said in the earlier comments I made, they truncate employees' rights in many ways. Now, employees don't have a direct role in elections, but they are important for their rights. And those rules have been modified in a way that makes it very difficult to object to the nature of the unit proposed, essentially nullifies the opportunity to challenge the inclusion or exclusion of certain employees within the bargaining unit. And we have found that in many cases that I've looked at, you simply don't have an opportunity to make your point in these proceedings in a way that will affect the actual outcome. So instead, an election takes place, and a union may in some cases be recognized as the bargaining agent, where employees really have not had a true opportunity to make their voices heard in the matter, nor has the employer, for that matter.
Mm-hmm. Well, let me follow up with this. Independent contractors are not employees under the National Labor Relations Act. In 2023, the NLRB issued a decision in the Atlanta Opera case that made it easier for the board to deem independent contractors to be employees. Your written testimony notes that this decision is another assault on worker choice. Can you explain how the board's efforts to undermine an individual's right to be an independent contractor impacts that worker's choice?
Yes, thank you again, Representative. Employees or service providers, I'll call them generically, have a choice as to whether to be employees or independent contractors. That's a very important right under our Constitution, a livelihood right. And the boards has truncated and restricted the arena of choice for employees by essentially making it very difficult to choose to be an independent contractor. In these decisions and many others, and in efforts to promote the joint employer rule that you mentioned also, it has the effect of cutting off that opportunity for employees. I think it's a fundamental right to choose those things, and I think that this board unfortunately has restricted that right.
Right, thank you. And again, the Employee Rights Act would create consistency and clarity across federal statutes with respect to employee and independent contractor status. The ERA provides essential protections for workers' rights, choices, and freedoms for the record. I have additional questions which I'll submit for the record, and with that, my time is out, and I yield back. Mr.